expert with a lot of this trust and estate planning. I'm going to have her lead for the conversation, but wanted to make sure to be on here as well because of the relationship and also because we work more in that team environment. And that's also why we've partnered with Patrick Stanley, who is the attorney who's going to be going through a lot of these different topics for you. So I'll let him introduce himself as well.
Thanks, Stephanie. Yeah, my name is Patrick Stanley. I'm a partner with a law firm called Comet Spethy in Scottsdale, Arizona. And our firm in general, and my practice specifically, is focused on assisting doctors, primarily physicians and dentists, with some of the more common legal issues they face. And I help set up estate plans, which is what we're here to talk about today. But my law partners and I also help doctors with several other areas, such as insurance issues, especially disability insurance, divorce and family law for doctors, business transactions, buying and selling group practices, setting up group practices, and then also litigation.
You know, and one thing that we've noticed, I would say, over the last couple of months is, with everything that the country's gone through, is there's been an increased awareness in individuals' mortality. And I think people are starting to realize how important it is to have a plan for their family if something should happen to them. Because without having a proper estate plan, which Patrick is going to talk about, we can unintentionally cause a huge emotional burden for our family, which can be time consuming and expensive. You know, when we spend our lives trying to protect our loved ones, the last thing we want to do is leave them in financial chaos. And so Patrick's going to spend some time talking about, you know, what as physicians you need to know from an estate planning standpoint. And we've worked with Patrick and Comet Spethy for several years, and they've done an excellent job in helping our clients to navigate the complex world of estate planning and as things change. So he's going to jump into that right now. So.
Yeah, I just want to echo that. We've worked with McKenna and Stephanie for several years, and I see our roles as complementary, where we set up the estate plan, and then McKenna and Stephanie will use that framework to achieve the client's financial goals. And we work with McKenna and Stephanie because we know our clients will be in good hands. And yeah, recently with everything that's happening with COVID-19, I've seen a pretty dramatic increase in requests for estate planning advice from my physician clients, particularly from ER doctors, intensive care doctors, hospitalists who are on the front lines of the COVID-19 pandemic, but also just in general with people who want, kind of, as McKenna mentioned, that it kind of brings mortality to the forefront in a way it isn't usually present, and it makes a lot of people, even young people, start thinking about what kind of estate planning they need to have in place. And given the amount of time we have together, my goal today is really just to give a broad overview of what I typically see in my practice, and you know, talking about the reasons for having an estate plan and what a typical estate plan I set up for physicians looks like. And then I'll give a broad overview of how the individual components work together. And I'm going to go into a little more detail. I'm sorry about that. I'm going to go into a little more detail on revocable trusts because they're often the centerpiece of an estate plan. We'll talk about how and why they work and the benefits of having them, what should and should not go into a revocable trust, generally speaking. And then McKenna and Stephanie will talk about the role of the trustee. And we'll also talk about why you probably still want to have a will, even if you have a revocable trust, and some of the more ancillary but still important parts of an estate plan, like powers of attorney and how they fit in. But this isn't an exhaustive list of the types of documents that can be in an estate plan. We just don't have time to go into detail on some of the other types of trusts that may be appropriate in some circumstances. Things like irrevocable trusts for asset protection, special needs trusts that you can use if you have a disabled child, AB trusts or credit shelter trusts, which are a specific type of trusts used for people who have assets in excess of the federal estate tax exemption, which at this point is $23 million per couple, about $11.5 million per individual. And I only bring those up because if you had a trust that was set up in 2010 or before, it may have been an AB trust that you may not need to have in place. Those put some restrictions on some of the things you can do in a trust. So if you have a trust from prior to 2010, you might just consider updating it or amending it. You know, one of the things I want to talk about is why you want to have an estate plan in place in particular. And I see two primary motivations. The first is control, and that's control over what happens to you, your loved ones, and your assets. You know, especially with respect to powers of attorney, and your revocable trust, if you become incapacitated, those can have provisions that can safeguard you and your assets. For my clients with children, you want to have control over what happens to those minor children in the event something happens to you and or your spouse, and then also your assets. You want to make sure, the number one concern that most of my clients have is to make sure that when they die, their assets will be transferred to the people they want to receive those assets in as timely a manner as possible. And if you die without an estate plan in place, state laws have rules on what happens to your assets in those circumstances it's called intestate succession. And those vary from state to state, but usually they provide that if you're married, your spouse will get everything. If you aren't married, your kids will get everything. If you don't have any kids, it will go up to your parents. If they're deceased, then it'll go to your siblings and to your nieces and nephews. And that may work for some people, but most people want to have a more tailored approach to what happens with their assets. And that's where a revocable trust can come in. And the other main reason to have a revocable trust in place is to avoid probate. If you die without an estate plan, or even if you just have a will in place, all of your assets have to go through the probate court, which is a long and expensive process where the court oversees every distribution of every asset. Notices have to be given to heirs and creditors. They have to have an opportunity to object. I recently helped a client with probating just one investment that her father had failed to put into a trust before he passed away. It was an investment account. She had no siblings. There was no one else that had any claim to any of the property in the investment account, and it still took about 8 months to get it transferred into her name. So even for an uncontested probate, you're looking at 6 months to a year before it can be concluded at a minimum. So those are just some of the reasons to have an estate plan in place. And as far as the kind of what you want to have in an estate plan, what I typically put into an estate plan for a physician, and this isn't in every case, but in most cases, we'll have a revocable trust, which I'll go into more detail later on, a certificate of trust, which is basically a summary of the powers and duties of the trustee that the trustee can then use with banks and with, transferring real estate, just used in the process of administering the trust so that the trustee doesn't have to produce the entire trust document every time they want to use or exercise one of their powers under the trust. And then I do still recommend that clients have a last will and testament, and then a durable power of attorney, a healthcare power of attorney, and then a living will, which is kind of a subset of a healthcare power of attorney. So that's the kind of the typical framework. As far as kind of what is a revocable trust, in some ways it acts like an LLC or corporation, but legally it's not considered a separate legal entity. Instead, it's a way of titling property so that you're not considered the legal owner of that property anymore. The trustee just holds title to the legal power or the property on behalf of the trust. And the trust agreement will outline what the trustee's rights and responsibilities are with respect to the trust property. And so, legally speaking, since the trustee, usually the initial trustee at least, is the person who sets up the trust. Since they're no longer the owner of the property, it doesn't have to go through probate court. Instead, upon the death of the initial trustee, the successor trustee, who you'll designate in the trust, will step in and transfer the property according to your instructions automatically and without the need for probate. And one of the good things about a revocable trust is that it can be revoked. It can be changed or amended at any time up until your death. So if you get divorced, if you have additional children that you want to make provisions for in the trust, you can change the trust, and it can be a very flexible document. And you can have provisions that require the beneficiaries of the trust to hit certain ages or other milestones before they receive distributions from the trust. And you can also use the trust to protect beneficiaries from creditors by restricting the beneficiaries' access to the trust assets until certain parameters are met. One thing a revocable trust cannot do is to protect your own assets from your own creditors. That's a topic for another day, but in order to do that, you really have to set up an irrevocable trust where you transfer the assets to a third party that'll manage the trust according to its terms. And that's where you see offshore trusts used. We've had clients use places like the Bahamas or the Cook Islands, or St. Kitts and Nevis. And there are some states in the US that allow you to set up these kinds of trusts too, so you don't necessarily have to go offshore anymore. But there are still restrictions on what you can do in an asset protection trust. You can't transfer assets if you know you're about to be sued or if you're insolvent. That would be a fraudulent transfer that a court could unwind. And you have to really give up control of these assets. The trustee has to be independent and has to strictly adhere to the trust agreement in order for there to be asset protection. But with the revocable trust, although it can't shield you from creditors necessarily because you can revoke it at any time, my clients often want to know what kind of property they can put in the trust. And this depends on the circumstances. Typically, real estate, so your house, a vacation property, you may want to put investment properties into it as well, but you wouldn't want to title them in the name of the trust. You'd want to create an LLC to own the property so that you're shielded from liability. The trust's other assets are shielded from liability in the event there's litigation or any claims involving that investment property. Savings accounts, this would include money market accounts, CDs, any other accounts that where you're not writing checks on a regular basis, but the money's just sitting there. Non-retirement investment accounts, and we'll talk about retirement accounts in just a minute, but this would be an account that's not linked to an IRA or a 401k or a 403b. Like the example I gave previously about my client's father who failed to put his investment account into the trust. You'd want to put those into the trust, or at least have them have the beneficiary of that account be the trust. And then another thing you want to have in the trust, tangible personal property. If you have jewelry, artwork, stamp or coin collections, things like that. That would go into the trust and then be distributed according to the trust documents after your death. And then interests in small businesses. And this, for an example of this would be if as one example would be an investment property that's held in a separate LLC, but it could also be an interest in a practice if your group practice allows it, or if you're a sole practitioner that's set up at PLLC, that could go into the trust as well. So that's generally what goes into the trust. Things that don't go into the trust, again, this depends on the circumstances. Typically, we don't transfer motor vehicles for two reasons. Number one, it's a bit of a hassle. It's an extra step to title a car in a trust's name. And then when you want to sell the vehicle, you have to provide additional documentation. And also it's often not needed. At least in Arizona, the motor vehicle division has a simplified manner of transferring title upon death. It doesn't require you to go through the whole probate process. Health savings accounts and medical savings accounts, typically those don't go into the trust. It can create some negative tax consequences. You could, in some circumstances, possibly name the trust as a beneficiary of the accounts when you die, but only as a contingent beneficiary. And then qualified retirement accounts, the 401ks, the IRAs. And this is in a bit of flux right now. Late in 2019, Congress passed a law eliminating what was called the stretch IRA. And the stretch IRA allowed you to stretch out the minimum distributions. If you passed away, the minimum distributions under some circumstances could be, instead of the beneficiary having to take all those distributions within the first 5 years after the original owner passed away, they could stretch them out based on their life expectancy. And now that's pretty much been eliminated, except for in a very few circumstances. So there are potentially tax liabilities if you have those in your trusts. So for now, we are advising people not to have their qualified retirement accounts in the trust, and to instead use payable on death designations to transfer at your death. So checking accounts too, unless you have a large amount in your checking account, it's probably better just to have a payable on death instruction, or to have a joint checking account if you, depending on the circumstances, with another person, so that transfers automatically when you die. And life insurance, in some circumstances, life insurance is an asset that doesn't go through probate because it's payable directly to the listed beneficiary and not to your estate. And there may be some reasons why you want the beneficiary of the estate to be the trust, like if you have minor children or there are no other liquid assets to manage the trust, you may want to. In some circumstances, you can set up a special trust just for life insurance called an irrevocable life insurance trust. But it's a bit of a gray area, and it'll depend on the circumstances for life insurance. And now that I've gone over a few guidelines on the revocable trust, the next question a lot of my clients have is who should be the successor trustee after they die. And while you can name an individual as a trustee, there are a lot of risks in doing that. The trustee will have control over all your assets, and even if they mean well, a lot of individuals, a lot of times, do not have the experience necessary to manage those assets. And a lot of the trust litigation I see involves trustees who are trying to do the right thing, but they're being accused of mismanagement or self-dealing with respect to the trust assets. So a lot of times my clients will want to have a corporate trustee in place. That's where professionals like McKenna and Stephanie, who are licensed fiduciaries and have the experience necessary to administer the trusts, come in. And I think with that, McKenna is going to talk a bit about managing the trust and the role of the trustee in the trust administration process.
Awesome. Thanks, Patrick. So when Patrick helps you set up a trust, one of the first things you've got to do is figure out who you want to be, which person or entity you want to be the trustee, and then the successor trustee as well. And you've got to remember that trustees have a fiduciary responsibility to the trust to make sure that the assets are being managed appropriately, and that when necessary, those assets are distributed to the beneficiaries per the rules of the trust. Now, typically, when the grantor of a trust or the person who sets up the trust will typically be the trustee throughout their lifetime, and they'll continue to manage the assets and fulfill any duties that are necessary. So if you were to set up a revocable living trust for your family, so in my situation, we have the Stephens Family Trust, and my husband and I are both co-trustees. So should something happen to one of us, and the other person would step in and handle any roles and responsibilities, which really at that point are very minimal. It's when something happens to that other trustee, either at death or if they become incapacitated through disability, cognitive issue, whatever the case may be, that's when the successor trustee steps in, and that's when things do get complicated. And so it's at this point that they have to assume all the roles and responsibilities and make sure that everything is being handled within the trust per all of the rules. So they have to consult with any advisors that are in existence, and they need to make sure that all the rules are being adhered to. And when you're choosing a trustee, you've got to look at making sure that whichever entity or person you're choosing is capable and that you have trust in them. Because just because you can look at your best friend that you've had your entire life and you trust them and you let them raise your children, but it doesn't mean that they are in a position, as Patrick said, to be able to make the complex financial decisions that are necessary to be a trustee. And so that's something that you really need to think about. When it comes to, I mentioned that you can have either a person as a trustee or you can have an entity as a trustee. And then oftentimes a grantor will choose a corporate trustee to manage the trust versus choosing an individual person, a family member, a good family friend, Uncle Joe, whatever the case may be. And one of the reasons that you're going to do that is you have to remember that it is very challenging to make unemotional decisions when you're close to a family or the beneficiaries of a trust. And oftentimes the decisions that are made can lead to hurt feelings amongst family members and broken relationships. And so by having a corporate trustee, you can actually avoid that by making sure that they're impartial and objective, and they're not going to be influenced by family relationships. And that can actually help to preserve the family relationships over the long term. Because I will tell you, when you have a death in a family, unfortunately, it brings out the worst in people, especially if there's money involved. And so we want to try to preserve the relationships that are in existence. Another reason that we would recommend using a corporate trustee is because of their experience and skill level. Oftentimes, there's a lot of different facets that go into estate planning and a lot of different types of trusts and types of tools that are used. And so a corporate trustee understands all of those tools, and they have that expertise that your best friend down the street might not have. And oftentimes if you have a personal trustee, they're going to have to go out and they're going to have to hire multiple advisors and pay all of those people to help them with that trust. They're going to have to pay somebody, an investment manager, to manage the assets. They may need to pay an attorney to help with language in the trust. They're going to have to pay a CPA to consult on tax issues. And so when you use a corporate trustee, oftentimes all those advisors are incorporated into the advice that you're getting. So you actually don't have to go out and hire each of those individually. The corporate trustee has all of those working for them. And I will tell you, we talk about making sure we're distributing assets according to the rules, and that's something that everybody's familiar with, or investment management. But one piece that people don't think about when it comes to trust is the taxation associated with it. And so having somebody that's well-versed in taxes, so Stephanie Tsang in our office is a CPA and has that expertise to understand what needs to be done. And it's important to make sure that you have a team, if you're trying to deal with these complex issues. Okay. The other thing to understand that, because when you use a corporate trustee, if you're wrapping all of these advisors into one, it can actually help save your beneficiaries money over time, saves them a lot of cost in the long run because they don't have to individually hire all of these experts. The other thing is these professionals are held to a much higher standard of performance, not only by the industry, but by the law, which can give you as a grantor peace of mind that your wishes are being carried out. They're responsible for timely, compliant reporting, and they're regulated and they're held accountable. And your personal trustees don't have that level of accountability, and it can actually lead to issues, as Patrick mentioned, with lawsuits and, again, disruption in the family, which we want to try to avoid. And one of the reasons to have an estate plan is to avoid some of that disruption. And I would tell you, as your personal situation gets more complicated, as your net wealth grows, as families become blended, having a professional advisor becomes increasingly more important, not only to preserve the assets that you've spent so much time accumulating, but to help preserve the relationships as well in your family. And that's why it's important to have that partnership and to work with a good attorney who can help make sure that everything is drafted appropriately. And so what Patrick's going to talk about now are some other components that go into the estate plan above and beyond just the living trust, so that you can make sure that you're not putting undue burden, either financially or even emotionally, on your family. Patrick?
Yeah. And one question I get a lot is why do I still need a will if I've got if I've got this living trust, revocable trust, and those two terms are used interchangeably. But why do I need to have a will in place It's still an important part of the estate plan, but they're much shorter than what they would be if you didn't have a trust in place. So what you want to have in a will, if you have a trust, is to have a pour over provision, which is basically states that instead of listing every beneficiary in the will, the pour over provision will say that whatever assets I own individually at the time of my death are to be transferred into the trust. And that's a catch-all that grabs up anything that may not have been put in the trust before your death. And although those assets will have to go through probate, there are expedited probate procedures for estates that have less than $75,000 in assets. So if you can keep it, at least in Arizona, I know every state can be different on what their probate requirements are. But in Arizona, if you do have less than $75,000 in assets, you can go through an expedited process. And wills are also an important place to make your wishes known as far as who will be the guardians of your minor children. And finally, if you don't have a will in place, if there is any property that's not in the trust at the time of your death, then it will go through that process of intestate succession. It won't automatically go to the trust. It's going to go to either your spouse or your kids or your parents or your brother and sister. You just don't have control over it if you don't have a will in place. So the wills are usually just a couple pages and list the formal requirements of the will, and then say everything after my last expenses are paid is to go to the revocable living trust that I've set up. So that's why you still need to have a will even if you have a trust. And you should also have powers of attorney in place. And these are really not so much after you pass away, but instead if you become incapacitated, if you have a cognitive decline, if you're in a coma or a vegetative state. And there are two types of powers of attorney. There's the durable power of attorney and the healthcare power of attorney. And the purpose of these is to allow someone, usually a family member, a spouse, if your spouse is still alive, to make decisions about your affairs if you become incapacitated. And the durable power of attorney is used for managing your financial affairs, bank accounts, real estate. But it's important to note that this only applies to the assets that are not already in the trust. And it's another reason why you might want to consider having a corporate trustee in place, especially if you're single, if your spouse has predeceased you, because if you become incapacitated, the trustee is going to step in and make decisions with respect to the trust assets. So McKenna and Stephanie have the knowledge and experience to know how best to manage those assets that your brother or your cousin or your friend may not have. And usually the way we draft the documents, though, is that both of these will only kick in if you're unable to make decisions for yourself. Typically we require certifications from at least one doctor, and in some cases 2 doctors, to the effect that you're not able to make those decisions. So that's the durable power of attorney. And as physicians, you're probably already aware of the healthcare powers of attorney, and that just allows someone, again, a friend, a family member, to make healthcare decisions on your behalf if you are incapacitated. And the living will, as I believe I mentioned, is it's kind of a subcomponent of that. It contains the specific instructions about life-saving or life-extending procedures, feeding tubes, surgeries, DNR instructions, things like that. And it's just good to have to make sure that your wishes are filled out if you can't make decisions for yourself. And that's a very brief overview of what a pretty straightforward estate plan may look like for a physician, but every situation is different, and this is definitely not an area where you can take a one-size-fits-all approach. So that's all that I had to talk about tonight, but I'm happy to take any questions.
Thank you, Patrick and McKenna. That was really, really good. A couple of questions that just kind of come to mind right away, and then I have some other questions that people have sent. But we tend to think of these things as you get a will, you get your trust set up, and then you don't really ever think about it. I mean, clearly you have life changes that happen, how often are people coming in? Because it seems like it's an ongoing relationship with whoever's setting up the trust, right?
It is, and I recommend that every 3 to 4 years, my clients just check in just to see if I can talk with them briefly, see if there have been any life changes. Like one major change that I mentioned was the changes to the stretch IRA requirements, or the elimination of the stretch IRA late last year. So I'd like to have people come back to me every 3 to 4, possibly 5 years, just to make sure that what they have in place fits their needs as time goes on.
And then McKenna, one of the questions about the corporate trustee is, I mean, there's a lot of people who are talking about individual investing, DIY. They're worried about costs of investing, and I think you did a good job of explaining that in the long run it may be beneficial to have this, because A, the corporate trustees have the knowledge, B, it's an institutional thing, so that if something happens to the trustee, it would be probably taken over by someone else at the corporation with a seamless transition, really. So the question though is, generally, how long does that process go on? Like, so if you were, my corporate trustee, and then do you basically, pass it along to, if something happens to you, you pass it along to your partners, and then, your firm just kind of keeps managing as long as my beneficiaries need it?
Yeah, as long as the beneficiaries are okay with it. If something were to happen, because typically when you use a corporate trustee, you have multiple advisors involved. So you'll have somebody that can help with the investment, you'll have somebody that can help with the taxes. And so that can continue as long as that trust is in existence, depending on the rules with the trust and how the distribution of the assets is set to take place. So that can continue until the beneficiaries choose that they don't, they can always choose to make some changes associated with that, but that can continue in as long as needed. And if one of the advisors is no longer there because you have a team, there is that seamless transition. I mean, if you didn't, there's always that opportunity, there's always that chance that you may not like somebody that you're working with that's part of the trust team. And in that case, a change can always be made. So you're not stuck to somebody for life just because of a previous relationship by any means. And the other thing, because there are a lot of people who do like to manage investments themselves, you can also have a corporate trustee that that can help with outside accounts. So it doesn't always have to be the same as well. So there's a lot of different ways to structure that, because we are coming in contact with a lot more people who want a little bit more management with their assets. Mm-hmm. But, and we've also seen co-trustees as well, so.
Okay. And then just a ballpark, like, is that a percent charge for the AUM under the trustee, or how do you guys, or how is it generally structured?
So typically the way that it's structured is there's a certain percentage that goes to the trust company, a percentage that goes to manage the assets. Mm-hmm. And typically, and it's usually a declining fee schedule. So it depends on the level of assets in the trust. And it also depends on the level of complexity. If we're just talking about normal general investments, or if we start to get a little bit more complicated, then oftentimes those costs can be a little bit higher. But usually you're looking at, for all of the paperwork, for all of the filing, for all of the management, you're talking about usually it can be done for under 2%. And you have to remember that includes all the filing, all the documentation, all the legal pieces that go into it, as well as being a trustee.
Now, is that 2% annually, or is that 2%?
Annually.
Okay.
Yep.
All right. Mm-hmm. Okay.
I was going to say, I saw a question too in the chat just about whether or not that if the corporate trustee was not in existence anymore. Mm-hmm. And that's a huge concern when we have a very volatile economy, and with you want to make sure, especially if you're setting up a legacy plan, that those people are going to be there for the long haul. And so aligning yourself with institutions that have longstanding track records is extremely important. And they have, there is insurance in place to make sure that that there aren't any issues typically in that transition if there were to be any financial issues by the institution. But you want to make sure that you're using a company that has a solid financial rating as well. That's extremely important.
One of, Patrick, one for you, a question that I think a lot of the listeners and the members of my group, they generally have, young children, minor children. I think one of the questions that's commonly asked is when children reach the age of majority in whatever state they're in, trusts can, of course, you can designate a greater time span, right? So they, when they turn 18 or 21, they just don't take their inheritance and blow it. You can stretch that out, right?
Right. And that's one of the main benefits of having the trust in place is that, whether it's 18 or 21, if a kid becomes a legal adult and they're given a pile of money, bad things can happen. So a lot of times what I recommend is that the assets will remain in the trust until they'll get a smaller payment at 21, and then maybe a bigger payment at 25, and then another payment at 30, and you can stretch it out as long as far as you want. You could have them getting the final distribution at 60 if you want. But that is one of the main benefits of having the trust, is that you're not just giving them a pile of money once they turn 18 or 21.
Right. Okay, let me go to a couple of the questions. So one of the things that a lot of doctors are doing now, I think a lot of people in general are doing, is real estate investing, but even their own homes. There's always a question of, do you retitle the house to put it in your trust? Is it good to do that at the time that you refinance? If you are refinancing, how do you do it? And do banks give a difficult time if you're trying to refinance a home that's already in a trust?
No, it shouldn't be that big of an issue if you're refinancing. If you're not refinancing, you can transfer it into the trust at pretty much any point. There's actually a federal law that prohibits banks from what's called accelerating the debt, demanding that the entire amount of the mortgage be paid at once if you transfer property that your personal residence into a revocable trust, because otherwise mortgages have a due on sale clause that if you transfer the property out of your name, you have to pay off the entire loan amount at the time of sale. There's a federal legislation that doesn't allow banks to do that in the event of a transfer to a revocable trust. So there shouldn't be any issues with the banks as far as putting it into the trust's name, whether it's at the time of purchase, at the time of refinance, or at any time in between. But you want to make sure you work with your lender on those issues and make sure that they know what you're doing.
Is a life insurance trust more bother than it's worth?
It depends on the circumstances. There are advantages to having what they call an ILIT trust, an irrevocable life insurance trust, in place. They are more expensive to set up, and they're a little bit of a hassle to manage because the premiums have to come from the trust. So it really depends on the circumstances and what you're trying to accomplish. Sometimes they're really not worth it, but in some circumstances, they can be a good estate planning tool.
Especially if you're dealing, depending on what your estate is at, and when we start talking about taxation, you have to look at what your goal is and what you're trying to accomplish, and determining how you're going to structure that estate plan, because it's not going to be the same for everybody.
Yeah.
Right. Okay. Let me go to some of the other questions that people have. Let's see. Okay, this is a common one for the younger members of the group. Do I need this if I'm single or I don't have any children?
I think it can be beneficial to everyone to have a plan in place, even if you are single and don't have children, so that you have the control over your assets if you pass away, and also to avoid, I think, as McKenna said, leaving your loved ones with the expense and the time-consuming nature of going through probate. So I think that probably for every physician, having an estate plan in place is a good idea.
Right.
Yeah, I mean, especially from the emotional standpoint, we've seen situations, too often where, somebody may not be married or may not have kids, but when something happens, your family, in most cases, is going to be upset. And the last thing they need to do is deal with the next 6 to 9 months. Instead of grieving and actually having closure, they're dealing with the estate and trying to work through the court system. And most of us don't want to put that burden on anybody else. If we can do a little bit of planning on the front end, then it can just make it so much easier for everybody around us.
Very good. So a question I don't, about revocable versus irrevocable trusts. When would you consider an irrevocable trust? In what situations would you consider that?
If you have, at least from my perspective, and I'll defer to McKenna on her perspective as well, but if you have a large amount of assets and you are in a situation where you don't have any claims now, but you might have some potential claims down the road, and you want to protect those assets for future generations, but you're not going to necessarily need them to live now, that might be a circumstance where an irrevocable asset protection trust is set up.
I mean, it's you've got to look at, typically we're going to recommend you're going to want an irrevocable trust when you're trying to remove those assets from your estate. And that's, for a lot of people, that's not a common thing. It's not something that they need to concern themselves with, especially when you look at where the exemptions are today. But for some people, it is a concern, or as we start to build generational wealth, it's, you've got to look at that. It's really a case-by-case basis. And if it's, oftentimes it is worth spending a little bit of extra money today just to protect those additional dollars down the road. So
I think in the physician scenario, even though we may not achieve by our normal employment generational or multi-generational wealth, we are at risk just simply from the asset protection of maybe exceeding your malpractice limits, and it's state to state dependent. So some states are a little bit more physician friendly in lawsuits, and others are more plaintiff friendly. And so, to whoever's asking, I think that's definitely a concern that you would need to address based on the scenario in your state. Speaking of state to state differences, so I'm in Arizona, you guys are in Arizona. If I get this set up in Arizona and then I move to Florida or I move to California, do the laws that were established when you established a trust take priority, or do you have to readjust that?
You can choose which state's law applies. And so if you set up a trust in Arizona, and if you have a will in Arizona, well, if you have a trust in Arizona, you can choose Arizona law to apply, and then if you move to another state, that choice of law will still be in effect. And then with wills, if you're resident in the state where you make the will and then move to a subsequent state, that state will recognize the validity of the will. At least I'm not aware of any circumstances in which that wouldn't be recognized.
Let's see here.
Having said that, though, the laws where you die, the laws of that jurisdiction will determine the probate process if you do have to go through probate, but the validity of the will be determined under Arizona law.
So I'm going to open up, if anyone on the Zoom here who's joined us directly has any questions, go ahead and unmute, or you can send a message on the chat and I can ask it that way. Some of you have been doing that. And if you want to just ask directly, please feel free. And okay, so while we're waiting, if anyone has any other questions, any tips or advice on determining who you're going to use as an executor of the estate?
Well, the executor is typically a family member. If you have a pour over will, the most important thing is going to be the successor trustee, and as McKenna was saying, that there are a lot of reasons to have a corporate trustee in place, like McKenna and Stephanie. But for the personal representative or the executor of the will, it's likely less important. I don't know if McKenna, do you offer services as the executor or a personal representative of the will?
And that can be done through the corporate trustee. I will say, if you want to name somebody, you can use a corporate trustee. If depending on the situation, you want to have somebody that has a good business sense, can deal with finances if you're naming a personal representative. And that's why too, when you start looking at the estate documents, when you start looking at guardianship and trustee and executor, those do not have to be the same people. And in most cases, they shouldn't be the same people, because the people you want raising your children are not the ones you want dealing with your business or your finances. And so it's okay to name separate people and have have the successor trustee, have the successor guardian, just in case. So you really got to look at your personal situation to determine that. And then if you are asking somebody on the personal side, you want to make sure that you talk to them ahead of time, and that you're getting their approval, and that they're okay, that this is not just a shock if something were to happen.
Yeah, and ideally, the personal representative really shouldn't, since everything should be in the trust, the personal representative should really be more focused on making the funeral arrangements and handling the personal aspects of the last wishes of the person who set up the estate plan, rather than really managing much of the financial aspects.
Is your estate protected from a malpractice suit? I think that just depends, right?
Yeah, it would depend on the circumstances, but typically not. Creditors can make claims against the estates of doctors.
All right. Well, I think, let me see if there's, so, I'm going to ask this question, but I already know what you guys are going to say, but in general, there's a lot of these online, wills and, basic level trusts and stuff. But I'm assuming that, there's a lot more nuance than you can answer in a form or a questionnaire. And so, but if someone wanted to just kind of get basically started just to get the will going, would you recommend them at least getting a online will or something like that, just to kind of get that done?
The concern I would have about a will is that it might seem pretty straightforward, but every state has different and very specific, and in a lot of cases, somewhat archaic steps you have to take in the execution process, where you have to have witnesses actually be in the same room to witness the signature, and then the notary has to be there as well. And so the concern is that if you don't do everything right, then the will could be invalidated, and then you've defeated the purpose of doing it in the first place. So even with something as simple as a will, a very basic will, you can get into trouble with trying to do it yourself.
I mean, I've also, to expand on that, I've had clients come to us after the fact who tried to even do a quick power of attorney online by some software that they had bought, and went through all of the process and couldn't get it to work. It's the same thing. You just don't know what you're getting. And in terms of, when it comes to these very specific situations, and when it comes to passing on wealth to your family and making sure that they're going to be okay, do you want to leave that to chance, is my question.
Right. And there's obviously, they're not going to give you any nuance or guidance or anything like that. And your experience, both of you, is hugely beneficial in individual nuances and things like that. So, but it is a question that a lot of people, ask. So, I think, let's see here. I think that's it. There was a couple of questions about asset protection, but I think we'll have to do that on a separate presentation. So I want to thank you guys for joining. Anyone else have any questions before we end this meeting? All right. Well, thank you guys for joining. And thank you, McKenna, Patrick, and Stephanie. I think this format is really good, and I feel like with the COVID crisis, everyone has understood the value of virtual meetings. But you know, we'll look forward to doing more of these. And so, thank you guys very much. Thank you for your time, and everyone who's on, please stay safe.
Thank you.
Thank you.
Thank you so much, guys.
Have a great evening. Thank you.
Bye-bye.